any comments that may slander, discriminate, or otherwise offend anyone, and we insist that you refrain from any such statements.
Fellow citizens, near and far, join NewRish Nital on Sugar City 90.3 for Fear No Favor.
Where is the cancer man? No rock come out for war.
Tune in to 90.3 on your FM dial. Log on to sugarcityfmsyncits.com or download Simple Radio app from the Google Play Store. And join NewRish Nital every Thursday night from 8 to 10 p.m. as NewRish Nital tackles the issues and take your call. Fear No Favor. Every Thursday night from 8 to 10 p.m. on Sugar City 90.3 FM. Fellow citizens, near and far, join NewRish Nital on Sugar City 90.3 for Fear No Favor.
Where is the cancer man? No rock come out for war.
Tune in to 90.3 on your FM dial. Log on to sugarcityfmsyncits.com or download Simple Radio app from the Google Play Store. And join NewRish Nital every Thursday night from 8 to 10 p.m. as NewRish Nital tackles the issues and take your call. Fear No Favor. Every Thursday night from 8 to 10 p.m. on Sugar City 90.3 FM.
Would you stand up and see your country dying and never lend a helping hand? Would you see your children's future dwindling, creating much disillusion? Or would we watch on idly, disregarding our self-sufficiency? Administration, wrecking all I know. I said no, no, citizens, let's unite and stand up for rights, all our lives and our lives.
Good evening and welcome to Fear No Favor. It has been a while. I think we did not have anything last week, Thursday, nor did we have anything the Thursday before. But hopefully we are back in harmonization of our efforts and we will continue to bring what we have to bring with respect to discussions, providing information, educating, and debating people on issues. The topic that I was supposed to do 3 weeks ago was centered around trial by judge only. There were many persons who were eager to tune in and hear the discussion and maybe be a part of the debate. You can still be, or the discussion, you can still be a part of the conversation. by calling 466-0903 and be a part of it. But I'll just make a presentation first of all, and then you can engage in the interaction by calling in. We're not forgetting that today is Mental Health Day, and if time permits, I would play a video that I would have produced on post traumatic stress disorder while making that presentation as part of my requirement for my doctoral studies in clinical psychology. It was done at Her Majesty's Prison, and I think that it is only appropriate. I think I got a few calls today indicating or suggesting that I might play that sometime in our discourse tonight. So let us be hopeful that time would really facilitate that. Now let us look at an article saying Kitts and Nevis moves to speed up justice with judge alone trial. Just let me read this so we can lay the foundation for what we are going to discuss in a bit. They said judge alone trials may soon be an option for persons in St. Kitts and Nevis who find themselves in trouble with the law after a bill was passed in Parliament recently. The judge alone trials bill received majority support after its presentation by Garth Wilkin, the Attorney General and Minister of Justice and Legal Affairs. In leading off the debate, Wilkins said judge alone trials would alleviate the backlog of criminal cases in the magistrate court and expedite justice delivery. He explained persons whose alleged criminal activity fall under the Firearms Act, Anti-Corruption Act, and Drugs Prevention Act could have their matter go directly to the High Court in some cases. What this bill intends to do is to enhance the efficiency of our criminal justice system by allowing certain criminal trials to proceed without a jury. We can significantly reduce case backlog and expedite the delivery of justice. This is particularly important in cases involving complex legal issues where a judge's specialized knowledge can lead to more informed and accurate decisions, the AG said. Wilkins said that the government's goal is to have a matter conclude within 18 months as opposed to the more than 2 years that currently exist. The AG noted in some neighboring countries, it takes upwards of 10 years for a matter to be completed. He noted that the judge alone trials are already a common practice in the magistrate's court, which handles serious criminal matters without the involvement of juries. The bill will extend this practice to the High Court, impacting approximately 30% of criminal trials. Wilkin highlighted that many countries in the Caribbean and Commonwealth already have similar legislation in their law books. Outside of moving the wheels of justice faster, Wilkins said The new law offers protection to potential jurors in high-risk matters whose vote on a verdict could be swayed by fear. This bill represents a significant step forward in our ongoing efforts to innovate and reform our criminal justice system, ensuring it is both efficient and equitable. As a small island nation, we must be at the forefront of adopting practices that not only enhance our judicial processes, but also align with our vision of a sustainable island state, Wilson stated. The bill will now head to the Governor General for assent. So that is the foundation. We would have trials, criminal trials, some of them, by way of a judge alone adjudicating. And it would have polarized to some extent persons in our federation. To what extent you have those in favor and those not so in favor, those pleased with it and those who feel it to be at their displeasure, you never know in this short space of time. However, we know that it would have started a national debate. So what I want to do is to try and give the advantages and disadvantages of a judge-only trial. Now, we understood the AG would have indicated that there seem to be backlogs in our court system, the magistrate court system, where once ago you would have gone to a PI, preliminary investigation, where the prosecution would present the case and the defense attorney would also defend his client to the best of his ability. In other words, he would not want that case to go upstairs. Upstairs because our magistrate hearings used to be downstairs when we were situated around the Palmer Square area, the Independence Square area. And when you say go upstairs, it would have meant leave the magistrate court and go up to the high court. So the job of a defense attorney was to prevent that matter from going any further and nip it in the bud at the magistrate court's level. So there's a backlog. You also spoke about high risk cases where persons might feel fearful of sitting on a jury panel to render or assist in rendering the ultimate verdict. And he also indicated that there are some cases where the complexity of the laws involved might be a little bit much for jurors and as such might cause unwanted delay in getting a result from the overall deliberation. Well, those are reasonable reasons as to why you might want a judge only. But the question lingers on who would decide which case would be tried by a judge only or judges only. We are not aware as to whether or not it would be one judge or several judges or two judges or several judges listening on a particular case. Which case would be most ideal for that? And even if the DPP or the prosecutors decided, well, this case A and B should be placed before a bench trial, which is similar to what you call trial by judge only. If they decided that case A should go to be tried that way, what options would the defense attorney, what would he have? How would he react to that? Suppose his client himself or herself doesn't want to be tried that way. What is the recourse? Because somebody would have to decide. And I don't know, even though it might be a method, a legal method of trial, we have to wonder if it would be black or white. Is it we say this way and it should go this way? Or the client, the defendant, would have a say in which way he would like his matter to be heard. I know they have some cases I refer to as hybrid cases where a defendant was given the opportunity to choose whether he or she would have liked his matter to be heard in the magistrate court, where a magistrate alone would be sole adjudicator, or he would have preferred his matter to be heard in the high court, where you have a panel of jurors being the adjudicators. That was what you call a hybrid situation. Now, is this trial by judge? Would the defendant have a choice? Could he and his attorney resist this particular case being tried that way? Those are questions that are still lingering on. We also have to remember that at times we have persons sitting on remand at His Majesty's prison for years before the matter is called up. And we have to be careful with that. They say justice delayed could be equated to justice denied. There was a case of one Remy Gums, very good friend and student of mine, who now works at the Nevis Island Administration over on Nevis. And he was there on a particular matter for an extended period of time. And he and his lawyer made a submission from a constitutional perspective, saying that it was unfair to have him there for so long without the matter being tried. And he won the case. You see, our constitution would have indicated that everybody is expected to get a fair trial within a reasonable period of time. However, you see that word, you heard that word, reasonable. Sometimes that word reasonable creates more problem within the legal environment than anything else. So the word reasonable is I don't. It is something subjective slash objective. You are trying to apply subjectivity in an objective way. And as such, what might be deemed reasonable for one person might not be deemed reasonable by another. We have to be mindful. It must be done within a reasonable time. The issue with that is what is considered reasonable time. Sometimes you might have precedent as to the average length of time that a matter might be completed. Sometimes cases might be distinguishable, and as such, whatever standard yardstick that might have been used to establish whether one case was completed in a reasonable time might not give the same result and satisfaction as another case for that same period of time. And like I said, the case of Remy Gums, he won that case based on constitutionality. So we have to be mindful. We don't want guys sitting over at HMP for a protracted period of time without getting due attention. Already you have many ways that a case can be delayed. Sometimes the defendant himself might not have had monies to pay his lawyer. The lawyers like to say that they were not properly instructed. They were not supplied with sufficient oxygen, meaning that the defendant just did not supply the necessary money that was charged. And could also be that that particular lawyer might be a popular lawyer, good lawyer, and then would have quite a number of cases to deal with. How they are prioritized, it is not based on that lawyer alone. It is depend on the system and where the preference scale would put that particular matter. The court may be ready, but sometimes the lawyer is not ready. And sometimes the lawyer and the court are ready, but then the defendant is not ready because his family and friends who would have been depended upon to provide the financial support might not be forthcoming. So we have to be mindful. One thing I don't like though is that we seem to have gone across and away from PI, preliminary investigation, to what they call paper committer. That is another story on its own because I do not believe that paper committer is very fair to defendants. Once a magistrate would have gotten some evidence from the prosecuting team and prima facie, just on the face of it, they decide that a case can be presented. They simply send the case up to the High Court, which is very unfortunate. The little fight and back and forth, the antagonistic and adversarial environment that used to embrace the PI, that is being removed. So imagine a lawyer may charge you $8,000 to represent you down in the magistrate court. And you would have had your PI going back and forth. Then eventually the magistrate would have reached a decision that that case should not go any further, meaning it would not go up to the High Court. So the only bill you would have had to incur was at $8,000 for the representation and the work of the lawyer at the PI. So something you don't have to go any further because as you go vertically upward, the more money you would have to pay. So $8,000 could turn into $30,000 when that matter is sent up to the High Court. The $8,000 that you might have given to your defense attorney to represent you down at the magistrate's court, you still have to find something extra for him to represent you at the High Court. So one would have to be very careful. And there's a gray area, there's a very nebulous area when it comes to lawyers defending people at these paper committers. Because then you have to get a lawyer to show up on your behalf. The lawyer might charge $5,000, $8,000. But then when the matter is submitted to the High Court or sent up to the High Court, you still have to give him a different set of money. So where the representation came from by the paper committee, it is said or it is expected that at a paper committee, you would have the prosecution team presenting the evidence. You might have the defense attorney who might have relevant and pertinent information because they might have had disclosure. You might have been able to use some of the information to counter what the prosecutors are saying. Might be able to do that. I am told that some magistrates, they do not allow for the back and forth. They say India is not for that. Go upstairs and you put some flesh onto the bone of your defense or onto the bone of your prosecution efforts. I don't believe that is fair. I believe that each side should be creating a bundle with information, pertinent information, relevant information. I'm the defense attorney. I present my information, my bundle to you. The prosecutors would present their bundle, and the magistrate job, if he's not a lazy magistrate, is to take that bundle, get some private time to put into the comparison that would have to be drawn with respect to the strengths of the information presented by both sides. And then maybe based on that, you realize, well, okay, this matter should go up. Or there's no need for this matter to go any further. But if that doesn't happen at the magisterial level, you're just sending up cases as if, well, I mean, you don't care. How could you really listen one side of a matter, an antagonistic matter, adversarial matter, and decide that one side is sufficient for it to go? So then why don't you listen to the defense? One-sided story and decide we don't care what the prosecution will come with. This matter ain't going any further, so this thing is dismissed. No, yeah, we have to be a little fairer. Both sides to submit their bundle. Scrutinization or perusal of the bundles must take place, and then a decision is made whether to send something up to the High Court or let it go no further. But to hear one side and this side, prima facie, you have a case to go. Something you'll be shocked when the defense counter whatever the prosecutors would have presented at the High Court, negating and diluting the evidence that the prosecution would have had. Because anyway, any horse will look fast in a race by itself. And to cause people to incur the extra $25,000 and $30,000 just to go upstairs, that could have been avoided. That could have been avoided. And then when something could have been stopped or nipped in the bud down at the magisterial level, it gone upstairs. People either got to go, the family got to go to the bank to get loans. Person got to go and work 2, 3, 4, and 5 jobs. Or they might have to go and rob, unfortunately, in order to pay these legal fees. So there are some back peddling aspect of that paper committal. In a high percentage of the time, it cannot be perceived as being fair, with one side presenting, and then a decision is made to send it upstairs. Maybe some lawyers like that, because it provides them with the opportunity to make more money from the clients. But I can't be fair. We're creating a criminal, we're manufacturing criminals. The very act of trying to defend somebody who allegedly committed a crime, that very same act can create a criminal, because you have to go and get the money to pay the lawyers. Not everybody. People don't put money down on an account and say, I mean, you got things for unforeseen contingencies. But getting in trouble sometimes, you never plan that. So paper committal sending you upstairs in a hurry, like an escalator. In a hurry. We have to start to get a circuit breaker. We got to reconsider certain things. Because it's just not going upstairs. The additional cost. Then you go upstairs, something is nearly passed. You make no case submission, it finishes. But you still have to pay the lawyer the monies. Even at times when the prosecution might have withdrawn a case, you have to pay the defense lawyer. Maybe it was based on the person who defending you. They realize they don't have a chance against such talented and skillful lawyer. So they withdrew the matter. If you have a lawyer who is not as skillful, they might decide to pursue. They might win something out of nothing. So there are some other factors that should be taken into consideration. Anyhow, that is my little piece on paper committal, which I would continue to embrace. Is not a very fair option. Not a very fair option. I understand that some magistrates were allowing something similar or parallel to the PI, adversarial discussion, antagonistic discussions, while others are just listening one side and standing up and say, well, upstairs is the place for the trial, not down here. You just look at the information and see prima facie there's a case to be heard. That can always be right. That can always be right. So now that they have a backlog as a result of not getting the cases moved forward fluidly, then it would have created a problem, an avoidable problem. But I guess the backlog is what deciding what it is. Now, trial by judge only. Would it be dictated to the defendant and his attorney? Would that person have a choice? Suppose somewhere along the way, based on how the trial is going, you ask to have that thing recused himself from the case. That's possible. You could ask a judge to remove himself. You could make a submission that the judge is removed from continuing with your matter. So a lot of discussion can be had. Now let us look at this bench trial. And we have to be mindful, want us to listen, and we can have our little discussion. Okay, criminal trials can be conducted either by a judge alone, which is known as a bench trial, or by a jury. The choice between these two formats carries significant implications for the judicial process. Public perception of justice and the rights of the accused. As we delve into this conversation, we will explore both the advantages and disadvantages of judge only trial, examining how they influence the fairness, efficiency, and overall integrity of the legal system. Let me make it absolutely clear that I think that I am in a position to have a discussion of this nature. Some people know me as a maths teacher. Some people know me as a chemistry teacher. Some people know me as an accounting teacher. But not many persons would know that I graduated with a law degree from University of London and I graduated with honors. Some may know, some might not know, so let me put that on the table as early as possible so you can feel relaxed that I at least have the mental acuity, the capacity to have a discussion of this nature. Let us look at the pros of judge-only trial. We are going to examine the expertise of the judge. One of the primary advantages of conducting trials by judge only is the legal expertise that judges bring to the courtroom. Judges are typically seasoned legal professionals who have extensive training and experience in interpreting and applying the law. Right? Judges are typically seasoned legal professionals who have extensive training and experience in interpreting and applying the law. This expertise allows them to navigate complex legal issues more adeptly or skillfully than a lay jury. Remember when they say they're sending up your matter, they said to be adjudicated by your peers. Now the question would now come up. Where is that? What is really someone or who are the peers of an individual accused of committing a crime? I think the age would have indicated that something you have complex legal issues. And something we witness it, those of us who would go to the courtroom to listen to certain cases. Even joint ventures create problems for some lawyers to deal with, much less members of the jury panel. Sometimes certain issues are difficult. But anyhow, this expertise allows them to navigate complex legal issues more skillfully than a lay jury. Research indicates that judges are more likely to focus on the law and the evidentiary standards required for a conviction, thereby promoting a fairer trial, according to Friedman 2005. So it is felt that judges are more likely to focus on the law and the evidentiary standards required for a conviction. For example, in cases involving intricate legal questions or specialized knowledge, such as financial fraud or intellectual property disputes, a judge's ability to understand and apply relevant legal principles can lead to more accurate verdicts. So there are some cases that might be a bit nebulous, a bit crowded, a bit grayish in area, but the lay person to wrap their minds around it properly. Because in as much as we say the facts are for the jury and the law is for the judge will still have to explain the law to the jury panel. You still have to explain it. And sometimes it is not so easy for persons to absorb the sum and substance out of the explanation that the judge would give. So that is another layer of complexity. Some jurors, regardless of how many times you repeat, you explain, they would never ever grasp certain concepts. And that's a fact. It's like teaching maths. You do some basic algebra, they hold on to it. You tell somebody to utilize the quadratic formula, some may hold on to it. You tell them to solve a quadratic equation via the graphical method. That might be gibberish to others. And you could think about jurors being like that. Some would understand better. Some would have given the position on a matter with respect to influencing or impacting a verdict, and not completely understanding what the law in reference to the evidence. How would you get this interwoven? So it is a bit difficult sometimes. So the expertise of the judge, very important. Then what about the efficiency in judicial process? Another notable benefit of bench trials is their efficiency compared to jury trials. Jury selection can be a lengthy process, and the deliberation period can add additional time before a verdict is reached. Just in some cases, to select a panel of jurors to sit as jury could be difficult for many different reasons. Something you might start out with 40 persons. Some people will tell you, I cannot sit on this matter because of my familiarity with this person, or I had an issue with this person already and I prefer not to avail myself to impact the verdict one way or the other. And you have efforts being made by the prosecutors to ensure that they pick a reasonable jury panel. You have the defense who would be able to make some objections. So the process could be a bit protracted. Just the selection of jury. Now, don't talk about the deliberation. When the matter is finished, or the prosecution would have finished its case, and likewise the defense, and then you go into the deliberation room to put your heads together and work out whether or not you think that person, based on the evidence that you heard, whether the person is guilty or not. So it is time consuming. By eliminating the jury and opting for a bench trial, which is a trial by judge, often proceed more swiftly, enabling courts to handle cases more effectively and reduce backlogs. So you move swiftly because you have somebody who is got the mental acuity, the capacity to do what they have to do. So things will just flow. According to a study by the National Center for State Courts, bench trials generally result in a shorter trial duration, allowing for quicker resolutions of cases. National Center for State Courts 2017. This efficiency can be particularly crucial in high-stake cases where timely justice is essential for the parties involved. Sometimes the protracted period before a matter is heard could create issues, and justice would be preferred more swiftly. So that would speak to the efficiency in the judicial process. Then you have reduced risk of jury bias. This is another advantage for the trial by judge only. Judges may also be less susceptible to biases than jurors. While jurors come from various backgrounds and may bring their personal benefits and biases to the deliberation room, judges are trained to evaluate evidence impartially. A study by Vidmar and Hans, 2007, highlights how jurors can be influenced by emotional testimonies or media portrayals, whereas judges are more likely to focus solely on the legal merits of a case. Some jurors can get too emotional, and if you have the media following around and everything else, That itself would suggest that it is a very important child. People might be swayed, people might be overwhelmed with the attention that the case is getting, and by turn, by transference, they might be very emotional. And then if you have persons in there giving emotional testimony, that could only complicate matters even more. For instance, in a highly publicized case, jurors may feel pressure. They might feel pressure to conform to public opinion, whereas a judge can render a decision based on legal criteria without such external influence. That's true. Reduce risk of jury bias. We're not saying that you don't have some jurors who could operate the same like judges, but then the average of those persons might be very low, and that might increase the risk of jury bias. Some people might argue the reverse, and we'll come to that when we look at the cons. Now, let us look at confidentiality and sensitivity, because some cases we like to say that these hearings should be in the public, but there are certain hearings very sensitive that they do not allow the public inside of the courtroom. So let us look at confidentiality and sensitivity. Certain cases may involve sensitive information or vulnerable victims. You might have a child well under age where public exposure could lead to further trauma or societal stigma. Let's take, for example, a female who might have been molested. Once that hits the public domain, they are members of the public society who try to stigmatize that individual, that victim. And let us suppose that it was a case that was made up for whatever reason. Once that person goes on trial, the defendant, he could win the case 100-0. There are still members of the public who would look at him in a type of way. And that is why certain cases may involve sensitive information or vulnerable victims where public exposure could lead to further trauma or societal stigma. Bench trials can provide a more confidential setting, which helps protect the privacy of those involved. In cases of sexual assault or domestic violence, for example, a judge-only trial may safeguard the identities and personal circumstances of victims, thereby encouraging more individuals to come forward without fear of public scrutiny. So said Burke, 2010. And we know we could have a problem like that because of the sort of adverse publicity that would be accumulating as that trial goes on. victims might not want to be associated with that. Even though they look injustice, they prefer to leave what is and live comfortably within themselves and maneuvering themselves amongst the public. Could be difficult. And that is a reason, justifiable reason, why some persons just do not push those sort of criminal matters any further. So confidentiality and sensitivity is an area of great concern where the trial by judge only could dilute it to reasonable insignificance and have persons coming forward, making the submissions, the complaints, and have their matters heard. Now, let us look at another area: contribution to legal precedent. Judge only trials can significantly contribute to the development of case law. Judges often provide written opinions detailing their reasoning, which can clarify legal principles and guide future cases. Precedent, you might not have anything actually written in law directly addressing a situation. In other words, you might say that the law might be silent on a particular issue, but then if you had a past trial where judges gave written opinions detailing their reasoning, these can clarify legal principles and guide future cases. That is referred to as precedent. And this is particularly beneficial in complex areas of the law, where established precedent may be lacking. Forgive me, I have a slight hiccup, so. But I meant I had to really come and do what I have to do on this topic. So it's a setting precedent. This is particularly beneficial in complex cases or areas of the law where established precedents may be lacking. The ability to set clear legal standards enhances the predictability and consistency of the judicial system, which is crucial for both legal practitioners and the public, according to Posner, 2010. There are many times when you might be trying a case and you cannot find the law directly written to assist you. Judges, experienced people, they would give their opinions detailing their reasoning, and then thereafter others coming behind in parallel cases may want to cite those precedents to help them in their own legal efforts. Okay, so we had the the pros. We spoke about the expertise of the judge. We spoke about the efficiency in judicial process. We also spoke about reduced risk of jury bias. We spoke about confidentiality and sensitivity. And we spoke about contribution to legal precedent. Now, let us look at the cons. And the first one that we would examine is perception of fairness. Despite the advantages, one major drawback of bench trials is the perception of fairness. A jury trial embodies the principle of being judged by one's peers, a cornerstone of democratic justice system. So we come back to it, to be adjudicated by one's peers. Are you saying that a judge could be considered the peer of a person who allegedly committed a crime? So that is an area of concern. Critics argue that a trial by judge alone can undermine the legitimacy of the judicial process, as it may appear to lack the communal involvement that juries represent, according to Harris 2012. This perception can affect public trust in the legal system, particularly if the outcome of a bench trial is viewed as biased or unjust. We could run that again. Critics argue that a trial by judge alone can undermine the legitimacy of the judicial process, as it may appear to lack the communal involvement of persons from the community, communal involvement that juries represent. This perception can affect public trust in the legal system, particularly if the outcome of a bench trial is viewed as biased or unjust. So that's perception of fairness. That's one of the cons. Then you have limited perspectives and deliberations. So this is another subtitled con. Limited perspectives and deliberation. Another concern is that bench trials limit the diversity of perspectives that a jury brings to the deliberation process. A jury consists of individuals with varying life experiences and viewpoints, which can enrich the discussion and lead to a more comprehensive evaluation of the evidence. Research indicates that group deliberation can improve decision-making quality by encouraging jurors to challenge each other's assumption and bias, according to Sustain in 2005. In contrast, a single judge may not benefit from such diverse input, potentially leading to a narrower view of the case. Very, very important con you have. Maybe I should just run through it again slowly. Limited perspectives and deliberation. Another concern is that bench trials limit the diversity of perspectives that a jury brings to the deliberation process. A jury consists of individuals with varying life experiences and viewpoints, which can enrich the discussion and lead to a more comprehensive evaluation of the evidence. Research indicates that group deliberation can improve decision making quality by encouraging jurors to challenge each other's assumptions and biases. In contrast, a single judge may not benefit from such diverse input, potentially leading to a narrow view of the case. Another con that we have to look at is potential for judicial bias. While judges are trained to be impartial, they are still human and may be influenced by their beliefs or biases. High profile cases, in particular, can place judges under significant pressure, leading to decisions that may reflect personal opinions rather than an unbiased interpretation of the law. Let us run that slowly. While judges are trained to be impartial, they are still human and may be influenced by their beliefs or biases. High profile cases, in particular, can place judges under significant pressure, leading to decisions that may reflect personal opinions rather than an unbiased interpretation of the law. A study by McCann in 2009 emphasizes a judicial bias, whether conscious or unconscious, can significantly affect case outcomes. This raises concern about the integrity of bench trials, particularly in cases where public opinion is polarized. So, potential for judicial bias. And then we must look at absence of community representation. This should be no surprise. The right to a trial by a jury of one's peers is a fundamental aspect of many legal systems, rooted in the belief that ordinary citizens should play a role in the administration of justice. Let us go through that again. The right to a trial by a jury of one's peers is a fundamental aspect of many legal systems, rooted in the belief that ordinary citizens should play a role in the administration of justice. Very, very important. Bench trials remove this critical element, which can lead to feelings of disenfranchisement among defendants. The absence of community representation may lead to a perception that the legal system is detached from the values and norms of society. So posit Harrison 2013. The absence of community representation may lead to a perception that the legal system is detached from the values and norms of society. A lot of us could see through that. This disconnect can erode public trust in the judicial process and foster skepticism about the fairness of outcome. Very, very key con we look at just now. Absence of community representation. Then we're going to look at reduced civic engagement. Conducting trials by judge only can also diminish civic engagement in the judicial system. Jury trials involve community members, fostering a sense of responsibility and connection to the legal process. Participation in jury duty is often seen as a civic duty, and engaging in the trial process can enhance individuals' understanding of the law and the justice system. When bench trials become more common, this public engagement may decline, leading to a disconnect between the legal system and the community itself, according to Tatum 2011. So, if I'm to summarize a bit, first let me get back to what we look at on the cons of judge-only trials. We had perception of fairness, and then we had limited perspectives and deliberation. Then we went on to potential for judicial bias. Then we carefully looked at absence of community representation, and then reduced civic engagement. Now, just knocking a conclusion together, the decision to conduct criminal trials by judge only presents a complex interplay of advantages and disadvantages. On one hand, the expertise, efficiency, and impartiality of judges can lead to more informed and timely justice. On the other hand, the lack of community involvement, potential for bias, and concerns about fairness can undermine the legitimacy of the judicial process. And, and as I reflect on these factors, it becomes clear that the choice between bench trials and jury trials should be made carefully, considering the unique circumstances of each case. Ultimately, a balanced approach that preserves the strengths of both systems while addressing their shortcomings, may be the most effective to promote justice in our legal system. Now, some people are listening, quite a number of them. There's also the opportunity, and pardon me for the sustained hiccup that I would have had from the time I started. It worsened a bit, but I tried to time the utterance so it would not have impeded anything of substance. Just pauses here and there where maybe they ought not to have been had I not been experiencing this strong hiccup. So we'll take a break, and then, as promised, we have about another few minutes. It's 9:19. So we'll do that, and when I come back, we'll put on the video that speaks to post-traumatic stress disorder, because we know that we are highlighting World Mental Health Day. And since I would have done this video on post-traumatic stress disorder, I feel it is ideal at this juncture to maybe present it to you once more based on requests and based on the fact that my utterance is being stuttered and disrupted, even as I essay my best. So we'll take a break and then we'll come back to the video.
Fellow citizens, near and far, join NewRish Nital on Sugar Soda 90.3 for Fear No Favor.
Where is man? Where is the cancer man? No run come out for war.
Tune in to 90.3 on your FM dial. Log on to SugarCityFMSinkits.com or download Simple Radio app from the Google Play Store. And join NewRish Nital every Thursday night from 8 to 10 p.m. as NewRish Nital tackles the issues and take your call. Fear No Favor. Every Thursday night from 8 to 10 p.m. on Sugar City 90.3 FM. Fellow citizens, near and far, join NewRish Nital on Sugar Soda 90.3 for Fear No Favor.
Where is man? Where is the cancer man? No run come out for war.
Tune in to 90.3 on your FM dial. Log on to SugarCityFMSinkits.com or download Simple Radio app from the Google Play Store. And join NewRish Nital every Thursday night from 8 to 10 p.m. as NewRish Nital tackles the issues and take your call. Fear No Favor. Every Thursday night from 8 to 10 p.m. on Sugar City 90.3 FM.
I would like to first of all say thank you to Commissioner Terence James and his Deputy Commissioner Denzel Harris for granting me permission to come and execute this presentation. But I would also like to equally thank you for volunteering to be part of the audience as I execute this particular presentation. Now, my presentation would be on post-traumatic stress disorder. And my presentation is going to be mainly in four Harris for granting me permission to come and execute this presentation. But I would also like to equally thank you for volunteering to be part of the audience as I execute this particular presentation. Now, My presentation would be on post-traumatic stress disorder. And my presentation is going to be mainly in 4 segments. The first one, I would indicate to you my reason for choosing this topic. The second one would be the diagnostic criteria for post-traumatic stress disorder. And then the next one would be assessment strategies that would be utilized to support the diagnosis. Then finally, I'll tell you about 2 evidence-based treatment intervention. One would be psychological in nature, and the other one would be pharmacological, meaning medication. Now, why did I choose this topic? It's because most of you would have experienced some sort of violence or other traumatic activities. Even the onslaught and the ravage of natural disasters. You might have experienced those traumatic events or activities. Or equally, you might know of someone who would have gone through those experiences that were aforementioned. And post-traumatic stress disorder is an anxiety disorder that could impact in a negative way persons who would have experienced psychological trauma before. Just by witnessing some sort of violence, some sort of tragic activity, or even hearing about events that would have impacted others in a way that would negatively ruin their lives. And it is important for us to be able to use a criteria when we are trying to diagnose whether or not somebody would have the symptoms of post-traumatic stress disorder. I will utilize a mnemonic. That is something that would aid my memory in helping me to explain to you what is post-traumatic stress disorder. I will use the very word trauma. That would be my mnemonic. The T would indicate that there was actually a traumatic event. So the T from trauma, traumatic event. The R would suggest that you're having re-experiences. That person would be re-experiencing those traumatic activities. Right? The A is avoidance. Person would try to avoid as much as possible places, persons, or activities that would tend to be associated with that same traumatic event, right? Then you reach on by you. You, remember we're using trauma as a mnemonic. Reach by you now. And one has to be mindful that due to the distress and everything that is going on within the person's mind, it causes them to be unfunctional, cannot function, whether from a social, occupational, or interpersonal perspective. It prevents them from functioning, so unfunctional. And then the M would suggest that the symptoms must last more than 1 month. You experience these symptoms for a week, 2 weeks, 3 weeks, that would not really bring you under the categorization of what is expected based on the diagnostic criteria. The symptoms must last for more than 1 month. Do we understand that? Then the final A is what? Arousal. Okay? The person is easily aroused. There's increased arousal. And this will be manifested by poor concentration, irritable moods, insomnia or lack of sleep, and hypervigilance. Hypervigilance is basically taking all sort of steps to ensure that no danger is lurking. You would check and recheck and double check and triply check to ensure that there is no danger, because this is what is powering your mind. You're thinking that you must doubly, triply ensure that there is no potential danger lurking for you. We understand us, far? Yes. And then we must now go on to the assessment. We just looked at the criteria and we used the mnemonic of trauma to indicate the diagnostic criteria for post-traumatic stress disorder. Now, you must have some assessment strategies to facilitate the supporting of those criteria, the diagnostic criteria. You must have some strategies. And strategies that I would employ would be screening. You have to screen somebody to ascertain whether or not the symptoms of those of post-traumatic stress. And there are instruments that are validated and are used in the screening exercises. You have spin, sprint, and you have span. Okay? Those are named acronyms of instruments that they would use to assess in the screening process. When you finish screening that individual, you must now do a comprehensive diagnostic interview. You have to make sure it's comprehensive. You talk to the individual. You get information from that individual by doing that interview. But despite doing that comprehensive diagnostic interview, you still have to rely on what you call self-reporting. The individual would self-report, so you give them a questionnaire and self-report about the symptoms that he or she would be experiencing. So you have the comprehensive diagnostic interview, then you have the self-reporting symptom questionnaire, a questionnaire that is designed to bring out information as the person responds to each and every question. But then even after doing the screening and the comprehensive interview, and even subjecting the individual to fill out this questionnaire, there are things about an individual that he himself would not really know. We talk about the Johari window. When you talk about the known, the unknown, the hidden, and the blind selves. So there are aspects about individual that he would not know. So therefore, we have to rely on somebody else who might be able to inform us or make us more knowledgeable as to information pertaining to that individual. And this is what we call collateral information. It could be a family member or it could be a friend, because sometimes you and friends get along better than family members, and that is a fact, right? And then when you would have collected your collateral information, you are now ready to conduct an evaluation of the DSM, Diagnostic and Statistical Manual of Mental Health Disorder. That is a manual, and it is labeled DSM-5. It is the latest edition. There you would go and you look for the literature as it would pertain to a particular mental ailment that would have been gathered through years of scientific research and clinical research. So you go finally to conduct that evaluation of the DSM-5 post-traumatic stress disorder criteria. And that is what you have to do in support of your diagnosis. When you would have completed all that, you want to make sure that persons are aware that there are evidence-based treatment intervention that can take place. One such may be the prime psychological treatment intervention is the cognitive processing therapy. Cognitive would relate to your mind, perception, reasoning, judgment, and those sort of stuff. So cognitive processing therapy, where the therapist would attempt to have those unhelpful thinking that would be pervading the mind of that individual to be substituted for more pleasant thinking. You understand? So you have to find a substitute. You cannot bully the person into stop thinking that way. You have to massage it into the individual where the unpleasant memory or the unhelpful way of thinking will eventually be substituted by more positive and forward moving development with respect to the thoughts that will go through that individual's mind. Now, what do they do at this stage? The individual is made aware of the thoughts that will pervade in his mind and cause the symptoms of post-traumatic stress disorder to be surfaced. So what you do is you cannot remember one of the stuff we had there for the criteria was avoidance. So the person would always try to avoid place, person, activities in order to not be reminiscing of the time when you experienced that trauma. So what you do now, you try to massage the person into accepting that whatever he went through, it would have had impact. So you cause the person to write what you call an impact assessment statement, saying, well, as a result of that traumatic event, it would have impacted the individual, it would have impacted family members, it might have impacted the country as a whole, or the world as a whole. So first of all, make him aware that there is an impact assessment, and he has to do a detailed written impact assessment so that he can be fully aware of the persons, the players, the stakeholders who were impacted as a result of that traumatic event or activity. Now, what you have to do after that is to let the person write about the most traumatic experience that they would have ever had. The most traumatic experience. So you see what you're doing is that you don't want to see something, you bring it. But you don't bring it and push it in the person's face. You invite them to take a peek here, and eventually, in a wholesome fashion, understand the entirety. That is why you started with the impact assessment in detail. So now the person will write about the most horrible traumatic experience that you would have ever had. Now you're asking the person to carry out adjustments, get those maladaptive adjustments substituted. But if you have to do that, you have to be able to recognize and then be able to deal with those. And that is where the cognitive processing therapy would come in. That is the main proven type that will alleviate the symptoms of post-traumatic stress disorder. Do you understand? And then that is the psychological aspect of work on the person's mind. Because we know that the mind could only hold that much in its memory bank. So if you have a mixture of good and bad, and you tend to substitute the bad with good, eventually that negative impact that is occupying your memory bank will be diluted to insignificance. Mind is not easy to take them, remove them off the memory bank. But if your quest in having it predominate what comes to the surface would be subdued by substituting it with more positive and helpful thoughts. Then you have the pharmacological approach. The pharmacological approach deals simply with using medication. Using medication, you have what you call selective serotonin repulsion inhibitor, right? It prevents serotonin from negatively impacting what you have. And the two types of medication that would be used in selective serotonin uptake inhibitors, you have sertraline and paroxetine. Sertraline and paroxetine. These are two medications that would enhance the person's well-being and put to rest many of the symptoms that the person would have been experiencing. Okay, so you had the psychological, you can do that alone. If you have to do one alone, most persons, most clinicians advising that you do the psychotherapy, where you talk and you replace the thoughts and everything within your mind. And then, of course, you have the pharmacological, which is the medication. Nobody at all would submit you to just medication because it is something that is psychologically impacting you. And as much as you can suppress certain things. You want to deal with the problem, not just keep it under suppression. So the best possible combination is a hybridization of the psychotherapy and the pharmacological therapy. It would have been proven that they work brilliantly together. And as such, that is what is being recommended. Okay? A combination of both the psychotherapy and the pharmacological therapy. Now, this presentation is supposed to be just about 5-7 minutes. But I always feel like I should leave a little room for even one or two questions. Now, but having said, impart that knowledge to you, I feel that you're now more aware and current about the mental disorder that is known as post-traumatic stress disorder that accompanies the very experiencing of violent activity, tragic activities. And we are now in a better position. If we know that we would have experienced it, you are aware now that there is help. There is help that was tested and there is treatment to be had. So you can now subject yourself to that sort of therapeutical sessions. And the CBT, the cognitive processing therapy, it is done over a 12-session duration. You can subject yourself with. If you know of somebody who is experiencing it, you are now basically equipped to make some observations and see if you can pick up symptoms and maybe make a suggestion to somebody so that you can have intervention. Sometimes we don't know exactly what is happening to us. If we can't define what is happening to us, then it will be rather difficult to ameliorate the unhelpful experience that your life is going through. Do you have any questions? Yes, quickly.
Psychotherapy and pharmacological therapy. This was the differentiate between psychologist and psychiatrist.
Yes, that's a very good question. What happened is that the psychotherapy would come more from a psychologist, and then the psychiatrist will have to ascertain what is going on within you and what medication he can prescribe. From most of the time, you do not find psychologists prescribing medication. It is psychiatrists who have to do a comprehensive medical examination and decide what will work best for that individual. But I'm saying in combination with psychotherapy, that can be the most effective form. Any other questions?
Why is it important to use both? What would be the issue if it's just the drugs alone, the pharmacological aspect?
Yeah, what happens is that you can give people drugs, you administer drugs to them, and that will subside the experience that they're experiencing. But then when the drug wears off, then they go back into the same way of thinking. You see, the post-traumatic stress disorder is more like a way of thinking, intrusive thinking. Your reasoning, your judgment, your perception. Usually you wouldn't find medication that can suppress that here forever. So what you do, you work
to get it suppressed, to give you a little bit more time, by a little more time, to work on the individual psychologically. It is work above the shoulder. Remember, we always say a man is a mind with a body, and not a body with a mind. So as much as you can have the medication suppressing considerably the state of the body, then you need to work above the shoulders to ensure that the mind will conform to more helpful thinking. Okay? Okay, thank you very much.
One more question.
Yes, sorry.
The PTSD, right? Can it be simulated by olfactory senses?
Say it again.
Can we smell create potential to create PTSD?
You mean post-traumatic stress disorder?
Yes, because I said possible remember with the location and stuff like that.
Right. Sometimes the smell associated with it? Yes, because let us suppose that you went to war and you can detect the scent of bodies. You understand? Decaying bodies. Somehow if you go somewhere and you experience that scent, it can cause you to re-experience what you would have experienced way back when you actually witnessed decayed bodies and the scent that was put out. So yes, that the aura, that is an actual part of it as well. It can help in any activity, place, or person that would be associated and cause the person to remember the condition that impacted them. They try to avoid that, but you have to massage it into them. But I don't think if you're trying to assist them, you want to submit them to the inhalation of a scent. You understand? Because then it can have physiological impact. So even though the scent might be one of the factors that can cause them to revisit and re-experience, you will not want to use that in your treatment process. You prefer to talk them to explain to them so they can identify and deal with it. Okay, thank you very much for being such of the audience. And I can admit to you that it is because of you why I'm actually doing clinical psychology. Because here is where I'm destined to help as many persons as I can. Once again, thank you.
Fellow citizens, near and far, join NewRish Nital on Sugar City 90.3 for Fear No Favor. Tune in to 90.3 on your FM dial. Log on to SugarCityFMSinkits.com or download Simple Radio app from the Google Play Store. And join NewRish Nital every Thursday night from 8 to 10 p.m. as NewRish Nital tackles the issues and take your call. Fear No Favor. Every Thursday night from 8 to 10 p.m. on Sugar City 90.3 FM.
Would you stand up and see your country dying and never lend a helping hand? Would you see your children's future dwindling, creating much disillusion? Or would we watch on idly, disregarding our self-sufficiency? Administration,
Welcome back to Fear Now Favor. I hope that you did get valuable and pertinent information with respect to trial by judge. There's a presentation that I put together and presented to you tonight. And the presentation on post traumatic stress disorder. I'm a bit laboring under some kickoff and there's no water around. So unfortunately, Sagacity would suggest that we bring tonight's program to a little early end, just about 12 minutes, and then we'll do a bigger program next week, Thursday. So thanks to those of you who messaged and who indicated that you would listen to it again before you go to sleep and who would listen to it tomorrow. Much appreciated that you could express your gratitude in such a short space of time. Well, enjoy what is left of your Thursday evening, and we'll meet up again next week. Thank you very much for your attention.
The opinions and statements made by the host and participants in this program are not those of the owners, advertisers, and management company of Sugar City FM 90.3, nor are such statements necessarily supported or endorsed by the owners, managers, or advertisers of this station. While we encourage all to share their opinions, we do not support any comments that may slander, discriminate, or otherwise offend anyone, and we insist that you refrain from any such statements.